you must be aware that new committee at WRC and ICI is in place, and I hope that the committee will work for the development of the fraternity. Further, on account of ongoing geopolitical crisis between Russia and Ukraine, it will impact Asian economy, but the impact will be polarized across the region. So now coming on the today's topic, today we had kept very important topic that is all about merger, demerger, and amalgamation at NCLT, which includes the recent landmark judgment also. And the speaker for the day is none other than our own CS Ashish Lalpuria ji. Sri Ashish Lalpuria ji is a well-known company secretary, and I request the members of the session to make the session live. Now I request, uh, now I am sharing my screen, the institute motto.
य एष सुप्तेषु जागृति य एष सुप्तेषु जागृति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्द्वैता 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 एतद्द्वैता.
Now I request our core group member and today's coordinator Rahul Dagaji to formally introduce the speaker. Over to you, Rahul ji.
Good afternoon, everyone. It gives me immense pleasure to introduce our today's faculty, CS Ashish Lalpuria ji. He's a fellow member of ICI with over 20 years of experience. He's also completed his MBA in finance from the NMIMS University and also a law graduate. He is amongst the very few members of ICI who started practicing NCLT since its very inception in 2016. His specialization includes mergers and amalgamations, demergers, restoration of companies, operation mismanagement, and many more other areas. He is an first minority shareholder in the Indian corporate history to contest a scheme of arrangement of a listed company and have it set aside by the Honorable NCLT after the same has been approved by the Honorable NCLT Mumbai bench. He's also carried out more than 50 schemes of mergers and amalgamations. His major groups for which he successfully handled and completed the scheme of amalgamation and arrangements includes the Vodafone Idea Group, the Shrem Group, Universal Hotel Group, Jyoti Laboratories Group, to name a few. Today, he will share with us his insights on the recent landmark judgments and precedents pertaining to the mergers and amalgamation. With this brief introduction, we welcome CS Ashish ji, and over to you, sir.
Good afternoon, everybody. I'm thankful to the conveners for having invited me to this session today. We actually, in each of our sessions, we try to ensure that practical aspects are covered, because practicality is what matters. Most of us have the knowledge which is there in our books and act and rules respectively. But the practical aspect is where experience is needed in order to complete assignment successfully. So I will now start with my presentation for today.
ठीक आहे, मग तुम्ही किती 4:30-5 ला निघणार आहेत ना? चालेल, ठीक आहे, मग मी चालेल, हरकत नाही. हा विचार येणार असेल तर मग येऊ दे, काय प्रॉब्लेम नाही, म्हणजे आधी आपणच आहोत, फक्त मग तिला आणि सोडा.
We request the members to please keep yourself on a mute so that the session can Go,
My
sir.
screen visible to everybody?
Yes, sir.
Yes. So the topic for today is all about mergers, demergers, and amalgamations at NCLT, including recent landmark judgments. We'll just go through the process very fast and thereafter come to those judgments. The views expressed in this presentation are entirely personal. References made to any government departments, authorities, benches of Honorable NCLT and Honorable NCLT are for knowledge sharing and research purposes only. So what was the effect of transition of scheme matters from the High Court to NCLT? As we are aware, prior to NCLT, all scheme matters pertaining to mergers, amalgamations, demergers, reduction of share capital were dealt with the Honorable High Court. So we always had to take services of advocates in order to complete our mergers because they had only the authority to represent before the Honorable High Court. So as a result of the establishment of NCLT, practicing professionals other than advocates got opportunity to pursue career at NCLT. So to list our matters, we needed to file a precipe for transferred matters for listing. So at the initial stage, right from December 2016 to January 2019, Honorable NCLT did not grant dispensation from holding meetings of shareholders to approve a scheme of amalgamation. So in every matter, you had to hold meetings, irrespective of the fact that there were only two shareholders, that is the husband and wife, and for that a meeting used to be held, and chairman was appointed, scrutinizer was appointed by Honorable NCLT, which ultimately increased the cost of the entire process. And apart from the cost, it used to consume about 2 months more time because newspaper ad used to be published 30 days notice for the meeting, etc. So the first dispensation was given by NCLT on 11th March 2019 in the matter of Malti Securities Private Limited, which was our matter, in which we presented before the bench consent affidavits from shareholders and made out a very strong case why meeting should not be dispensed. So on 11th March 2019, the Honorable NCLT dispensed meetings of shareholders, and till date, if you have consent affidavits of all shareholders, meetings are being dispensed. So NCLT also, and there is an NCLT judgment on dispensation of meetings in the matter of DLF Limited. Generally, if NCLT orders meetings, nobody goes and challenges those orders. People prefer to hold meetings. But DLF went to NCLT and made out grounds that when consent affidavits have already been obtained, then the meetings should not be held. So there is this NCLT judgment in the matter of DLF Limited. And in Idea Cellular Limited, Ahmedabad bench, the Gujarat High Court also has said that amalgamation cannot be stopped if nothing contrary to law is established. There may be some violations of company law. There may be some other complaints, inquiries, etc. pending, but amalgamation cannot be stopped if nothing contrary to law is established. So that is covered in this judgment. So mergers and amalgamations under section 230 to 232. So stages of the merger process. Firstly, prerequisites. Prerequisites to decide whether the case is fit for amalgamation and or demerger. The second is estimation of cost involved in the process. Third is arranging for prerequisites required for filing application with NCLT. Fourth is filing of first motion application with NCLT. Thereafter, course of action after filing of first motion application with NCLT. Course of action after passing of first motion order by NCLT. Filing of petition with NCLT, second motion. Hearing of petition, course of action after sanction of the scheme. So these are the 9 stages which we will explain in brief. So the first stage, understanding the necessity and objective of merger or demerger, financial statements and annual return of the companies, details of immovable assets, if any. So if the transferor company has immovable assets, we need to understand the implications of stamp duty because the merger will result in transfer of assets from the transferor company to the transferee company. Many states have exemption if wholly owned subsidiaries are being amalgamated into the holding company. So the stamp duty is not payable, but the same depends from state to state. So thereafter, details of cross-holding and reduction of share capital, if any, because if cross-holdings are eliminated, it is a possibility that post-merger, the paid-up capital of the transferee company would be lower than what it is presently. So then we will have to incorporate section 66 also. It will be a composite scheme under 232 read with section 66 of the Companies Act. Thereafter, income tax provisions with respect to demergers to be considered. So under demerger, I believe there is a section 219(2) with the conditions need to be complied, else the demerger will be treated as a transfer and taxed accordingly. So swap ratio or exchange ratio. So if it is not a wholly owned subsidiary which is getting merged with the holding company, we need to have a valuation from a registered valuer who will recommend the swap ratio or exchange ratio. Thereafter, goodwill, capital reserve. So mergers may result in creation of goodwill or capital reserve that needs to be taken into consideration. Details of pending litigation between the company and the shareholders or the company and its creditors. So this is very important because these things have a tendency to stall the merger, because if shareholders are fighting with each other, there will not be absolute majority, and once some shareholders approach the NCLT, there can be a roadblock to the merger. Similar is the case with creditors. Although most of the mergers are not scheme of arrangements between creditors, they are arrangement between shareholders. But even though creditors file applications before NCLT that the companies are not paying my dues, so they may be directed to pay my dues before the scheme is sanctioned. Qualifications, if any, in the auditor's report. In the ordinary course, people may not, the regulatory authorities may not go into the auditor's report and may not take any action. But the moment you file an amalgamation, and in that the auditor's report for the financial statements which have been attached to the petition or the application contain any adverse remarks or qualifications, then the observations of the regional director include that they should be directed to file for compounding of offenses, etc., which the companies would not have done in the ordinary course. So that also needs to be taken into consideration. Jurisdiction of the company across states. So there may be companies having registered offices in different parts of the states. There may be some companies having registered office in Mumbai, some company having registered office in Delhi. And if they are a part of the same scheme, separate applications need to be filed with different NCLT benches, or else the registered office of the companies need to be shifted to one state and one application can be made to that particular NCLT. Although the president has the powers to consolidate the files pertaining to different states into one state, so that only one NCLT bench has the jurisdiction. So jurisdiction of the company across the states. So there is a order of the principal bench. We will just see that. So statutory compliances and records should be up to date, because the chartered accountant appointed by the official liquidator would be requiring access to the records of the transferor companies. Sectoral regulators. We need to understand the sectoral regulators which are applicable. For example, if it is a real estate company, RERA would be applicable. So in case of a retail industry, Future Group and Reliance, so they took approval of CCI, Competition Commission of India. So sectoral regulators need to be identified. Provisional financial statements need to be ready. So from the date of filing, the provisional financial statement should not be older than 6 months. Thereafter, defining undertaking and statement of assets and liabilities in case of demerger. So in case of a demerger, there needs to be a separate undertaking, and all statements of assets and liabilities should be available, because the same is required to be submitted before the regional director, because one of the observations of the regional director is that the statement of assets and liabilities needs to be submitted. So now cost and fees. Statutory fees that is to be paid by Bharat Kosh. Presently, it is rupees 5,000 for one particular scheme. So the entire scheme, it is 5,000 rupees. First stage, second stage till the final disposal, fees has to be paid only once. So the fees is only 5,000 rupees. Thereafter, fees for filing first motion application with NCLT. So the first motion fees is 5,000. It has to be paid at the first instance, and thereafter no fees has to be paid. Auditor's fees. So the auditor who will be appointed by the NCLT to assist the official liquidator, his fees is generally average of 5 years fees, but NCLT benches fix a higher fee subject to a maximum cap of rupees 2 lakhs. So the auditor's fees needs to be taken into consideration. Advertisement cost is applicable in case meetings are being ordered, or if meetings are not ordered, then at the time of final hearing, the advertisement needs to be published. So advertisement cost needs to be taken into consideration. Thereafter, professional fees for valuation report. So in case of valuation where the merger is not between wholly owned subsidiaries, IBBA registered valuer prepares the valuation report. So the fees for that needs to be accounted for. Chairman and scrutinizer fees in case meetings are held. So in case meetings are ordered, chairman's fees and scrutinizer's fees would be required to be paid. Thereafter, payment of cost to regional director and official liquidator if ordered. Earlier, there was a practice to levy 25,000 rupees per company as a cost to be paid by each company involved in the merger to the regional director, and 25,000 rupees per company to be paid for all transferor companies to the official liquidator. So presently, it is not being ordered. So if it is ordered, then the same needs to be paid. Thereafter, stamp duty on transfer of assets of the company. So stamp duty on transfer of assets needs to be calculated well before we embark on the amalgamation, because that can be very substantial. So a brief idea needs to be taken as to what can the implication of stamp duty be. Other incidental expenses like printing, stationery, etc. So other incidental expenses also need to be taken into consideration. And lastly, the professional fees being charged by the professional. So thereafter, the cost calculation sheet looks like this. So professional fees paid to registered valuer, first motion application to NCLT, auditor's fees for transferor companies, that is average of last 5 years, subject to a cap of rupees 2 lakhs, advertisement cost 25,000 to 40,000, payment to regional director as per the direction of NCLT if ordered, payment to official liquidator as per direction of NCLT if ordered, stamp duty, chairman and scrutinizer's fees as per NCLT direction, other incidental charges, that is printing, notary, franking, stationery, conveyance, etc. Thereafter, prerequisites for filing application to NCLT: preparing checklist, drafting scheme of amalgamation, demerger, conducting board meetings, appointment of registered valuer for finalizing the swap ratio, consent of shareholders and creditors, if it can be made available. So if consent of shareholders is made available, meetings are dispensed, and presently at Mumbai, the practice is that you can serve notices to creditors. There is no need of holding meetings. Obviously, if you will pray for a meeting, the tribunal will allow holding the meetings, but it can be avoided. You can serve notices to creditors. And it is mandatory presently to get NOC from secured creditors before the date of final hearing. So the first motion order may not entail holding of any meeting whatsoever if you have consent of shareholders on affidavit for all the companies which are a part of this amalgamation. So auditor's certificate for accounting treatment under section 133, that is with UDIN, authority to professional to file first motion application and appear before NCLT. So stage 4, filing. So preparation and submission of application to NCLT, joint separate application in form NCLT 1, synopsis in paragraph form, list of dates and events separately, NCLT checklist, notice of admission in form NCLT 2, board resolutions, scheme of amalgamation arrangements, latest audited financial statements, provisional financial statements. NCLT president have powers to consolidate applications of different jurisdictions. So if you have more than 2 companies and they are having registered offices in different states and they are falling under different NCLT benches, then an application can be made to the principal bench who will order consolidation of the files before the bench concerned with the transferee company. So this is an order which we just see pertaining to Stargaze, which is the principal bench order. So this order of the principal bench is in the matter of Carnival Films and Cinema Ventures. So this was passed by the principal bench, and yes, I just read this order, which is a short order. This is an application filed under Rule 16D of NCLT 2016 with a prayer for transferring 2 petitions pending before the Mumbai and Delhi benches of the NCLT to the Ahmedabad bench as the registered office of the transferee company situated within the territorial jurisdiction of Ahmedabad bench, where a petition of transferee company for approval of the scheme has been filed. It has been pointed out that the Ahmedabad bench has already issued notice for the first motion, and the petitions pending at Mumbai and Delhi are yet to be placed before the respective benches, although the petitions have been filed. In view of the above, we direct that CACAA number so and so pending before Mumbai bench and CACAA number so and so pending before NCLT New Delhi bench be transferred to Ahmedabad bench. We direct that those petitions be heard with CACAA 113 of 2018. These parties through their counsel are directed to appear before the Ahmedabad bench on 29 November 18, the benches of NCLT New Delhi and Mumbai are directed to transfer all the files concerning the aforesaid cases to Ahmedabad at the earliest, preferably within a period of 7 days. List this matter on 29 November 2018. So in this manner, the NCLT principal bench ordered that the files of the other states should be transferred to the state where the transferee company is located, that is the Ahmedabad bench. So next is valuation report for swap ratio, list of directors, shareholders and creditors. The valuation report has not to be attached, it needs to be prepared and kept ready. So list of directors, shareholders and creditors, consent on affidavit from shareholders and creditors. Creditors, you can pray for notices to be served, that will be accepted. There is no issue whatsoever. So meetings can be avoided. Updated memorandum and articles of association, very important, because we have seen cases where memorandum of association is not updated. The share capital mentioned at the end of the memorandum is very old. It is 1 lakh rupees, whereas the present capital, authorized capital, is 1 crore rupees. So it needs to be updated with all the alterations in place. So certificate of accounting treatment issued by auditors, printing single side on standard legal paper and restriction up to 200 pages per volume. So there is a request which has gone from the bar to the Honorable President that now A4 page should be allowed back to back so that we can save on paper. So hopefully legal paper and one side printing would be replaced with A4 paper with both sides printing very soon. Margin top bottom 4 centimeters, right 2.5 centimeters and left 5 centimeters and double line spacing. Signature initials on each and every page. 3 copies in paper book form, brown files, 1 original and 2 photocopies duly stitched in green thread. Affidavit verifying application and memorandum of appearance. Covering letter with office copy, because they need to give you an acknowledgement. If we go without our office copy, the file is not accepted. Bharat Kosh payment receipt and e-filing receipt. So the filing fees receipt also is needed. So thereafter, course of action after filing the application. So once your application is filed, you need to follow up with the registry for removal of office objections, if any, and follow up for numbering of the application accompanied with details of courtroom allocation about 2 working days. Presently, the process has gone online, wherein you can file petitions online. The scrutiny status is also reflected online, and once you see scrutiny clear, thereafter, after a few days, the petition number also will be available in the login itself. However, the court allocation is not available online. That also will be made available online shortly. So that is why we need to check the cause list of all the courts on a daily basis to understand the date of the first hearing. There are 5 benches in Mumbai. We do not know which court our matter will be allocated to. So we need to check the cause lists of all the courts on a daily basis. So preparation for the hearing, proper attire, blazer, preferably black or dark blue, and tie for women, and blazer with any sober attire for women. Fact sheet summary of the case to be kept handy with page numbers. This is very important because some judges have this practice. What is the net worth of the transferee company and the transferor companies? Please tell us immediately. So unless you have the fact sheet in hand or the page numbers in hand, it is very difficult. They will ask you the turnover. They will ask you as to what is the business of all the transferor companies and the transferee company, what is the rationale of the amalgamation. So we cannot just keep on turning pages. All such types of information needs to be very, very handy. So preparation of minutes of order. So as per the practice in most of the tribunals, the minutes of order, that is a draft order, also needs to be prepared by us and carried for the hearing, because the benches do not have that much of time considering the volume of the work involved. So the draft order has to be prepared by us, and that should contain the SIN, PAN and ward number of income tax, appointed date, business of the company, rationale, etc. Contents of minutes differ from courtroom to courtroom. So there is a slight difference in the minutes of order format from courtroom to courtroom. So that also needs to be taken into consideration. The draft order needs to be prepared as soon as your petition is filed, because the scrutiny clearance, numbering and court allocation hearing can take place very fast. Sometimes it is within 2 to 3 days. So there should not be a scenario where you go to the court and say, sir, we have not prepared the minutes of order, kindly grant us a short adjournment. So when the court is ready to hear us, we should be ready before them. obtaining the details of the auditor appointed by NCLT. So that details are filled by the court. They will appoint an auditor from the panel of the official liquidator, and the fees will be fixed, which will appear in the order. So soft copy of the minutes of order and application. So after the hearing, the soft copy has to be emailed to the court, and the application, that is a first motion application, the PDF file also needs to be emailed. So extra copy of application, in case of physical hearing, you have filed the documents with the registry. If it is not reached the court, then the matter may be adjourned since hard copies are not available with the bench. So it is advisable that an extra copy of the application be carried along. Thereafter, follow for the order in case hearing is completed and matter is reserved for order. So there can be two consequences after the hearing is completed. Either the matter is allowed in open court, so the order can be uploaded directly. If it is reserved for order, then we have to wait for the orders to be pronounced. It will appear in the cause list, subsequent cause list for pronouncement of order. So accordingly, once the order is pronounced, thereafter it will be uploaded. So in case of a delay, we need to follow up with the court officer to have the matter pronounced. The orders need to be pronounced. So once the order is pronounced, make an application for certified true copy of the order. This is very important because once we file INC 28, it calculates the days from the date of making the application for certified true copy of the order. For example, if your order is passed on 1st April, you make the application for certified true copy on 10th April, and you get the order sometime after 20 days. So 20 days is what the court has taken. You have wasted 10 days time in getting certified true copy of the order. So you will have only 20 days time to file the order with ROC. So preparation and submission of documents with respect to RD's query letter. So once the first motion application has been allowed, we serve notices to ROC, RD, income tax, official liquidator. So RD sends a standard questionnaire which needs to be replied by the companies. So now the course of action. Yes, in case of dispensation of meetings of shareholders and creditors. So arranging documents and information from the company as per auditor's checklist, service of notice to sectoral regulators, registrar of companies, regional director, official liquidator, income tax department, other regulators wherever applicable. Filing affidavit of service to NCLT containing acknowledgements of service as directed, inspection of documents and conducting of audit by auditors appointed by the NCLT. So the course of action where meetings are held. So arranging documents and information from the company as per auditor's checklist, service of notice to the sectoral regulators, thereafter issue of notice to shareholders, creditors at least 30 days before the date of meeting in case dispensation is not granted by NCLT, advertisement of notice of meetings in at least one English newspaper and in at least one vernacular newspaper as directed by NCLT in its order, file the affidavit of service to NCLT, convening the meetings, filing of chairman's report with NCLT on affidavit in case of meetings of shareholders, creditors, along with scrutinizer's report. Thereafter, inspection of documents and conducting of audit by auditors appointed by the NCLT. So now the second motion stage. So your first order has been passed. You have served notices to all the regulatory authorities. You have filed affidavit of service. So now comes the second motion stage of filing the petition before NCLT. So it contains a synopsis in paragraph form, list of dates and events separately, updated memorandum and articles of association, latest audited financial statements, board resolutions, scheme of amalgamation arrangement, copy of order passed by Honorable NCLT allowing the application, certificate of accounting treatment as issued by the auditors, affidavit of service, chairman's report, affidavit verifying the petition, memorandum of appearance. So again, the very same process, it is filed, it is scrutinized for defects, if any. Once the scrutiny is cleared, it is registered, a petition number is allocated. It is heard in the very same court in which the first motion order was passed. So attend the hearing and press for admission of petition and seek date for final hearing. Publish advertisement for final hearing. Issue notice to regulatory authorities again intimating them the date of final hearing. File affidavit of service. Check official liquidator and RD report for specific observations. There are two types of observations. One are standard observations, the other is specific observations. So specific observations need to be dealt with more carefully because they are pertaining to your scheme of amalgamation. File affidavit in reply to RD's report. So the RD issues its report. There are observations. We need to file our affidavit in reply to the RD's report, and thereafter RD files a supplementary report. So that supplementary report needs to be obtained. This practice depends from courtroom to courtroom. There are some courts which insist on supplementary report, and some courts state that once you have filed a reply to RD's report, that is perfectly fine, as it is the representative of the RDs present in all the hearings, without which final orders are not passed. So this is the flow in just snapshots. First motion or application order, affidavit of service. Affidavit of service for the chairman, chairman's report. Second motion, petition admission order, publication of final hearing notice, affidavit of service, final hearing order, obtaining certified copy of order with scheme, filing with ROC and stamp office. That is for stamp duty adjudication. So representation by authorities to NCLT. So on one hand, ROC files his report with the regional director. The regional director files his report with the NCLT. Auditors appointed by NCLT, they file their report with the official liquidator. The official liquidator files its report with the Honorable NCLT. Only thereafter the final hearing takes place in any matter. So course of action after approval of the scheme. Filing an application for the certified copy of order immediately upon pronouncement of order. Payment of cost to regional director and official liquidator through Bharat Kosh portal online if ordered. Transferor company should not have any pending SRN with ROC. So this is very important, because if there is a charge form which has been filed belatedly 5 years ago and you have not condoned the delay by making an application to the regional director, that SRN will remain open, and therefore the file of that company in ROC records will not be closed till the time the SRNs are closed. So we need to ensure that there are no pending SRNs with ROC. So transferor company should not file any other form with ROC except form INC 28 once the final hearing is completed. So earlier that form DPT3 was not in STP mode. So people used to file DPT3 after getting the order from NCLT. That form used to be pending for more than 3 or 4 months, and that prevented the approval of INC 28. So as a result, the status of the transferor companies was never changed to amalgamated. It was stuck in the system. So once you get the order, you file the order and follow for the approval of INC 28 directly, so that the status of the transferor companies changes to amalgamated. Thereafter, filing of certified true copy of order with ROC in form INC 28 within 30 days from the date of receipt of certified copy of the order to make the scheme effective. So your scheme will be effective immediately upon filing of INC 28 with ROC. Application letter to ROC for combining the authorized share capital for to be attached in form INC 28 of the transferee company. So in our scheme, there is a clause for combination of authorized capital. So although it is subject to provisions of section 232(3)(I), which deals with payment of stamp duty on the differential authorized capital, but an application needs to be attached in form INC 28 to enable combination of authorized capital. Thereafter, filing of order with stamp authority within 60 days from the date of filing the order or from the date of passing the order, or as specified in the order. Some courts have this practice of giving 60 days. Some courts will give you a time of 60 working days. So that effectively increases your time by about 15 days to file the order with the stamp office. So stamp office, we need to file the order. So there are two types of observations of the regional director. One is standard observations, the other is specific observations. Standard observations generally appear in all schemes of merger amalgamations, whereas specific observations are pertaining to your scheme where they have noticed something which needs to be clarified. So the standard observations include compliance of AS 14, that is Ind AS, passing of accounting entries, and compliance of AS 5, that is Ind AS 8, etc. Comply with the appointed date circular. So MCA has come out with a circular dated 21st of August 2019, whereby it has clarified that an appointed date can be 1 year antedated or 1 year previous. So you can go back by 1 year, you can go ahead by 1 year, but in case you are exceeding any of these timelines, you need to justify reasons in the scheme. So every time the RD will point out that companies need to comply with MCA circular dated 21st August 2019. Thereafter, to comply with section 232(3)(I) of the Companies Act on differential fees on authorized share capital. So the authorized share capital fees as per the old Companies Act was lower. The authorized share capital fees as per the new Companies Act is higher. So in case a company, transferor company, is incorporated under the Act of 1956 and the authorized capital is being merged with the transferee company, the calculation of the authorized fees already, authorized capital fees already paid, and the authorized capital increase fees as per the prevalent fee slab is calculated, and thereafter the difference between the two has to be paid. Only then the capital will be combined. So 232(3)(I) deals specifically with this, that the difference arising upon the combination of authorized capital fees needs to be paid. So the decision of income tax authority are binding. That is another observation. So we always undertake that yes, income tax authorities' decisions will be binding upon the companies even after the amalgamation. The scheme attached to the application and petition are the same. So it was brought to the attention of NCLT that the scheme which is attached to the first motion application and the second motion petition were different. So nowadays they insist on an affidavit stating that the scheme attached to the application and petition are the same. Thereafter, a general observation is interest of creditors are to be protected. So that the companies undertake, yes, that interest of creditors would be protected. So some specific observations which are rarely seen, it depends from scheme to scheme. So the companies did not have any business in the last 2 or more years. So the RD says that when you don't have business, what will be the synergy? Why do you want to merge the companies? Why should the companies not be struck off? So that needs to be explained, because there are many times unsettled assets and liabilities due to which amalgamation is being taken place. Thereafter, companies are having negative net worth. So RT says that you have negative net worth companies, what is the use to merge them? But then there are other commercial reasons for which the merger is taking place, and there are settled judgments. The law has settled that negative net worth companies can also be amalgamated. Auditors of company have qualified and or has made observations. Companies are directed to compound the offense. So this is one issue which is there, and we should always keep in mind to check the auditors reports, etc., before filing the scheme of amalgamation, that if any qualifications are there, then this direction of compounding of offense will arise. And many a times, if there is indeed a violation, the companies have to file an undertaking with the regional director that they will compound the offense post the amalgamation. Thereafter, objection of the creditor to the proposed scheme, NOC to be obtained. So if any creditor is objecting the merger, the locus is 5% of the outstanding debt as per the records of the company. Although an arrangement between the shareholders do not affect the creditors, but courts are bound to hear the creditors also, which may delay the amalgamation. So it is better to settle the issue with the creditor and obtain NOC. Appointed date is too old, change the appointed date. In many cases, it happens that the merger lasts for more than 2 years or 3 years, etc. So if the appointed date is too old, the RD may say that it may be changed to some recent date. The appointed date is too old. Thereafter, violation of section 185, 186 with respect to loans and investments. This is commonly seen. So observations arise, and we have to undertake to make the offenses good. So that is another specific observation. Obtain NOC from RERA. So the moment the RD sees that the name of the company contains the word real estate, construction, buildings, etc., they will always say that the company should be directed to obtain NOC from RERA, Real Estate Regulatory Authority. So that also needs to be taken into consideration. However, if the shareholding pattern of the transferee company is not changing by more than 50%, then RERA is not applicable. And if wholly owned subsidiaries are being merged into the parent company, NOC from RERA is not required. Transferor company has foreign shareholder, issue notice to RBI, obtain NOC from RBI. That is because you need to issue shares to foreign shareholders. The transferee company will have to issue shares to foreign shareholders. So RBI will come into picture. You need to comply with the guidelines of RBI. Companies attract the NBFC provisions, that is a 50-50 test, obtain NOC from RBI. So in many cases, the purpose of the merger is to avoid the 50-50 test. So it is explained to the RD in several occasions, and NCLT has also passed orders that consequent to the scheme of amalgamation, the 50-50 test will not be attracted. So the main rationale for the amalgamation is to avoid NBFC provisions. Thereafter, transferor company has open charges. There are no secured creditors in the books of the transferor company, but in the index of charges, there are charges which are open. They are not satisfied. So RD has observed in many cases that what about the charges which are open? Although the same will be amalgamated with that of the transferee company, but then many a times undertakings have to be given that we will ensure that necessary application is made, necessary forms are filed to close those charges which are already satisfied. Change of name upon merger. So earlier courts used to take a conservative view wherein the name of the transferor company was to be used by the transferee company post amalgamation. So even recently RD in his observations mentions that it will create confusion in the minds of stakeholders. So the change of name of the transferor company, that is the transferee company, will use the name of the transferor company post the amalgamation. That should not be permitted. But then there were judgments of high courts, etc. So NCLT is now permitting change of name of the transferee company to that of the transferor company. Thereafter, transferor company is a foreign company corporation. Similar approvals be obtained in accordance with the laws of the other country. So if there are names which, if the transferor company is not based in India, then we need to take approvals from the laws of that country where the company is situated. So now coming to some specific observations, on 27 July 2020, Reliance Holding USA Inc. Transferor Company 1 is a foreign company corporation incorporated pursuant to and in accordance with the General Corporation Law of the State of Delaware, as amended from time to time, having employee identification number so and so and having its principal office at so and so Houston in USA, and does not fall within the jurisdiction of this tribunal. Accordingly, similar approvals be obtained by the above said transferor company 1 in accordance with the laws of United States of America. So the company replied that as far as the observation made in the report of the regional director is concerned, the petitioner company submitted that transferor company 1 is a foreign company incorporated pursuant to and in accordance with the General Corporation Law of the State of Delaware and does not fall within the jurisdiction of this tribunal. The petitioner companies further submitted that similar approvals as may be applicable will be obtained by the transferor company 1 in accordance with the applicable laws of United States of America. So thereafter, the next one is Future Enterprise Limited and others. In this case, NCLT Mumbai bench ruled that objection at the first motion stage, that is just before the holding of the meetings of shareholders and creditors, is premature and that the same can be dealt with during the second motion stage or before the final sanction or approval. That is CA 24 of 2021, Amazon.com versus Future Enterprise Limited. The scheme contemplated consolidation of the logistics and warehousing and retail and wholesale businesses by Future Group of 19 transferor companies into Future Enterprises Limited, sale of logistics and warehousing and retail and wholesale business and related assets as a going concern on slump sale basis to Reliance Group. An application was filed with NCLT for holding meetings of shareholders and creditors by the Future Group for the purpose of considering the scheme. Amazon objected to the scheme citing emergency arbitrator order of Singapore International Arbitration Center, wherein the EA, that is emergency arbitrator, restricted the Future Group from taking any steps with respect to arrangement with the Reliance Group. The objector Amazon.com cited that as per their agreement with Future Group, FRL would remain the sole vehicle for the conduct of retail business carried on by FRL and would not transfer its retail assets of 1534 retail stores without the consent of FCPL and also not transfer to its retail assets to a restricted person. The list of restricted persons as mentioned by Amazon.com in FCPL shareholders agreement includes Reliance Group. Amazon filed petition before Delhi High Court to enforce the emergency arbitrator order against the Future Group, in which a single bench directed status quo to be maintained with respect to all matters in violation of EA order till the final order. Future Group approached the division bench of Delhi High Court against the above order, wherein the said bench stayed the order of the single bench judge. Amazon approached the Supreme Court against the division bench order of Delhi High Court. The Supreme Court held that NCLT proceedings will be allowed to go on but will not culminate into any final order sanctioning the scheme. The question before NCLT was whether the court at this stage can consider the objections filed by the applicant objector, that is Amazon.com. NCLT observed that in view of the order of Honorable Supreme Court dated 22nd Feb 2021, the bench does not have any doubt that it is well within its rights to allow the applicants to hold meetings of various stakeholders, creditors, etc., which is only the initial stage in the process of approval of the composite scheme. The bench, as per the direction of the said order, will not pass any final order sanctioning the scheme. The Supreme Court further wide order on 9 September 2021 clarified that the parties have approached the SIAC for vacating the emergency award and that authorities, that is NCLT, CCI and SEBI, not to pass any final order for a period of 4 weeks. The current status is that the meetings are yet to be held. Future Group has approached Delhi High Court seeking directions to NCLT to proceed further in the matter. The second judgment is on GMR Infrastructure Limited and others. The scheme contemplated amalgamation and demerger of GMR group companies. The objector, who was neither a creditor nor a shareholder, contended that GMR has not disclosed the latest financial position as their application is more than 6 months old. The question before NCLT was whether the intervener objector had any locus to object to the present scheme. In this case, the NCLT Mumbai bench ruled that the objector, who is neither a shareholder nor a creditor, has no locus to object the scheme. So, the application was filed and the objector further said that the latest financial position of the company is not available. However, the applicant companies reiterated that no material change in the financial statements from the time of filing of the application and date of hearing, and that the time gap between the filing and hearing was beyond their control, as NCLT was listing only urgent matters due to the pandemic, and that they had filed the interlocutory application seeking urgent listing of the matter. The applicant company too, being a listed company, is governed by SEBI LODR regulations 2015, and the financial statements for the period ended on 31st March 2021 and 30th June 2021 is published on the website. Therefore, the objection of the objector is rejected. NCLT further observed that the bench is of the considered view that the objection raised is untenable on 2 grounds. Namely, the objector is neither a shareholder nor a creditor and has no locus to file intervening application at this stage. The objector has not furnished any order or award restraining the approval of this application, nor has any decree in its favor, and that there is no material change in the financial statements within the 6 months' time, as the applicant company is a listed company and is obliged to disclose the financial statements as per SEBI LODR. So that objection was overruled and NCLT proceeded to pass orders in the case rejecting the objection. So this order, the next case is pertaining to Kumaka Industries Limited, decided on July 2020. In the instant case, NCLT Mumbai bench approved a scheme of arrangement wherein the petitioner, in a guise of a scheme, was contemplating ratification of illegal reduction of share capital done in the year 1998, despite objection raised by the RD and one minority shareholder. The scheme contemplated ratification of reduction of share capital without High Court approval. So this reduction took place in 1998. They filed the scheme in 2013 that they want to ratify that. Whereas the reduction was done without High Court approval. Regularization of allotment of shares in IPO against the terms of issue. Earlier in 95-96, there was a lot of 100 shares and 50 shares, and we need to apply for 50 or 100 shares respectively. So this company accepted applications for in lots of other than 50 and 100 shares, encashed the monies and allotted shares against the terms of issue. That was also a part of the ratification. And thereafter, issue of bonus shares to public shareholders with promoters foregoing their rights. So there were 3 things contemplated. So the NCLT observed that the term arrangement is a term capable of widest import. So the NCLT said that arrangement is wide, it cannot be predicted and calculated how big can it be and in which form it can be. Arrangements can take place on multiple hues and a bewildering assortment of forms. The fairness of the scheme qua the objecting shareholder has also to be kept in view in line with the celebrated Supreme Court judgment of Mir Mafatlal versus Mafatlal Industries. So objections of regional director are more on the procedural aspect than anything else, and it has not raised any objection regarding illegality in the scheme or against public policy, hence they are overruled. The objecting shareholder holds only 15 shares and thus lacks locus standi to object, and even on merits, the objections are unsustainable. So this order was passed by NCLT Mumbai bench, which sanctioned this scheme. So appeal to the enclad by minority shareholder, Company Appeal 136 of 2020, decided on 20th October 2020. So this minority shareholder was me, Mr. Ashish O. Lalpuria, the minority shareholder holding only 15 shares, filed an appeal against the impugned order of NCLT. The observation of NCLT, the proposed scheme of compromise and arrangement should not be violative of any provisions of law or contrary to public policy. Past records show irregularities and non-compliances due to which action was taken against the company. Objections raised by RD need to be given weightage and seem to be just and reasonable for dismissing the petition. The duty of NCLT is to ensure that before sanctioning of the scheme, all procedural aspects to be complied, failing which a wrong precedent would be set by which companies would violate the law and have it ratified by the court under the umbrella of scheme. Compliance of law in itself is a part of public policy. No actions must be pending against the company by the public authorities before sanctioning of the scheme under section 230 of the Act. NCLT should encourage compliance and not default. So the Honorable NCLT, the Appellate Tribunal, set aside the decision of NCLT and rejected the scheme of arrangement. So the order of Mumbai NCLT was set aside. The NCLT held that in case of illegality, there is no locus. Even a minority shareholder or any other person can bring to the attention of the Honorable Court that the scheme is illegal. So it was not required that he holds the requisite shareholding, that is 10%, as contemplated under section 230 subsection 4 of the Companies Act. Another judgment is Baramati Agro Limited, decided on 20th of September 2021. The scheme contemplated the scheme of amalgamation and arrangement between group companies. One of the rationale for the scheme was the transferee companies having 21,675 shareholders holding A-class equity shares. Out of 21,675, approximately 21,000 are shareholders holding small amount of equity shares in the transferee company. The smaller shareholders of the transferee company have been requesting for regular dividends on their investments since they are not interested in seeking management control or running the operations of the transferee company. Considering the shareholding pattern of the transferee company, it is difficult to pass on the benefit of dividend to these small shareholders. The transferee company had received requests from its smaller shareholders to redeem their investments within a fixed time frame and also start paying dividends on such investments on a regular basis. In view of this, it is proposed to convert certain A-class equity shares into 9% cumulative optionally convertible redeemable preference shares of rupees 10 each. So in short, the scheme envisaged conversion of equity shares into preference shares. So we will just see this landmark judgment passed by NCLT Mumbai, which has now been challenged by ROC Pune before the Honorable NCLT. So this was this judgment passed by Court 2. Yes, so this is the part which I just read, 21,675 shares. The equity shares are proposed to be converted into redeemable preference shares. So in this, the RD also had made its observation. Yes, ROC Pune in its report stated in para 9 that part D of the petition contains conversion of equity shares into preference shares, which is not permissible to issue redeemable preference shares against the existing equity shares, as its value, terms, rights are different and cannot be terms as same kinds of shares to exchange in ratio for consideration. Further, MCA-wide letter dated 3rd August 2019 dated letter number 3rd August 2019 dated 27 July 2020 has stated that one litigation is ongoing with respect to conversion of equity shares into preference shares and vice versa, whereby reclassification of such type was rejected by ROC Delhi, and has also asked for comments on the conversion of equity shares into preference shares or vice versa. It is submitted that the equity shares are having rights different to that of preference shareholders, which include voting rights. Further, the instant scheme is placed before members of the transferee company having only 48.45% of value, which is not representing majority. Hence, such conversion may be considered undesirable. So that is what ROC put in its report. So the same were reproduced by the regional director in its report. So the company has replied, apropos observations in paragraph 4FI of the report of regional director is concerned, the petitioner company state that the interpretation and reference of the ROC Pune is incorrect. The petitioner companies further state that the conversion of shares from one type to another for example, from equity shares to preference shares, is not barred by any provision of law, and in fact, in law, such conversion only amounts to reorganization of the share capital of the companies, which is permissible under Section 61 of the Companies Act 2013. In accordance with the relevant provisions of the law and judicial precedents being relied upon the petitioner companies, a scheme of compromise or arrangement may involve increase, consolidation or subdivision of shares or reduction of share capital. Therefore, the conversion of equity shares into preference shares as sought by the petitioners under the scheme cannot be deemed to be impermissible. In reply to the comments of ROC Pune, the petitioner companies submit as follows. Pursuant to Section 43 of the Companies Act 2013, both equity share capital and preference share capital appear in the balance sheet under the head of share capital. And as per provisions of Section 43 of the Companies Act 2013, there can be only two classes of shares, that is equity and preference, and combination of two depict the total share capital. When shares of one class are converted into other class, for instance, equity shares into preference or vice versa, and value of the paid up share capital does not undergo any change, the subscribed and paid up capital remains unchanged. Only the nomenclature of the shares undergo a change. Thereafter, under Section 230 of the Act, a scheme of compromise or arrangement may be in the form of reorganization of share capital of a company, and the explanation appended to subsection 1 gives an inclusive definition to the expression arrangement as including reorganization of share capital. The Supreme Court in SLP 984 of 2006, Rajendra Prasad Gupta versus Prakash Chandra Mishra and others, held that courts are not to act upon principle that every procedure is to be taken as prohibited unless it is expressly provided for by the court, but on the converse principle that every procedure is to be understood and permissible till it is shown to be prohibited by the law. As a matter of general principle, prohibition cannot be presumed. So the Supreme Court also said that if there is a prohibition, it has to be clearly established. It cannot be assumed. So with regard to MCA letter referred by ROC Pune dated 27 July 2020, petitioner company submitted that as per the settled principle by the Honorable Supreme Court in several cases, the said letter cannot be binding on the court or tribunal or petitioner companies in this case unless the same are made a part of substantive law or delegated legislation. And in support of the same view, the petitioner companies would like to highlight the following case laws. So they have supported their argument with certain case laws. In case of Shikshan Prasarak Mandal versus Ramesh Narayan in 2016, no circular or view of the executive can bind the court when interpreting a legal provision. As regards office memorandum, local justice observed that office memorandum cannot be used to interpret a provision of law. No importance can be given to office memorandum. Office memorandum can always be withdrawn, modified or amended on the whim of the executive government. Reference Mohanlal versus Principal Secretary. In Bengal Iron Corporation and others, it was held that government's clarification and circulars are merely their understanding of the statutory provisions and are not binding on quasi-judicial authorities. It is only for the courts to interpret the statutes. The Supreme Court in the matter of Subhash Ramkumar Bin and versus State of Maharashtra held that an administrative instruction issued cannot substitute with the requirement of a notification in the official gazette, and that it cannot possibly be a substitute for a notification which stands as a requirement of the statute. The settled position of law is that no government order, notification or circular can be a substitute of the statutory rules framed within the authority of law. The regional director has filed its supplementary report dated 16 December 2020, taking into consideration report issued by ROC Pune and stated that the petitioner companies have replied satisfactorily to part 4, A to E, and the other matters be considered on merit. Further, the regional director had stated in the report that the regional director is not convinced with the reply filed by the petitioner companies with regard to MCA letter referred by ROC Pune dated 27 July 2020. So from the material available on record, the scheme appears to be fair and reasonable and is not contrary to public policy. And thereafter the scheme was sanctioned. So this order has been challenged by the ROC Pune before the Honorable NCLT, because MCA did not want conversion of equity shares into preference shares, and therefore in the form for conversion also they removed this option. in Form SS7, they removed this option of conversion of equity into preference. But now a way was found through Section 232 by which it can be done through the court. So since this has become a precedent, the ROC Pune has filed an appeal before the Honorable NCLT to set aside this order. So presently the order is stayed and the matter will be listed for hearing again later in the month of March. Yes, so this is the RD observations of ROC Pune which we just read from the order. The company's reply also, which we said that there is no prohibition, which we read from the order. Yes, and this is with reference to the Supreme Court order, which we referred in that order as well. In continuance to above, company also stated that as per the settled principle, the circulars cannot be binding on the court or tribunal. So RD was still not convinced by the reply filed by the companies, but NCLT overruled it and did not find merit in the arguments of RD and went on to sanction the scheme and held that the company cannot be restricted to reorganize its paid up share capital by converting its equity shares into preference shares or vice versa as a part of the scheme or compromise or arrangement, as the same is impermissible under the Section 43 and 61 of the Companies Act 2013. Another recent judgment in case of Patel Engineering Limited, NCLT Mumbai, 15 November 2021. 14 wholly owned subsidiaries of Patel Engineering Limited were proposed to be merged with PEL, that was the holding company. The companies filed application for dispensation of meetings of equity shareholders and unsecured creditors on the ground that the transferor companies are wholly owned subsidiaries of transferee company and relied on the judgment of Bombay High Court in Mahamba Investments Limited versus IDI Limited 2001. HDFC in CSA 915 of 2017 NCLT Mumbai and various other judgments that meetings of equity shareholders and unsecured creditors is not required in case of transferee company when the transferor companies are wholly owned subsidiaries of the transferee company. NCLT Mumbai did not agree and directed holdings of meetings of equity shareholders of transferee company and obtaining consent affidavits of at least 90% of the unsecured creditors of the transferee company. We will just see this judgment passed by NCLT Mumbai. So this judgment involving 14 companies was passed by NCLT Mumbai on 15th of November 2021. This was court number 4 which passed this judgment. So they have given details and rationale of the amalgamation. And thereafter they have issued instructions, which we will just see. Yes. The transferee company has already submitted the consent affidavits from 22 secured creditors having outstanding amount of 1881 crores, while its additional affidavit dated 21st July. The 6th transferor company has also submitted the consent of debenture holder along with the application. Following is the list of secured creditors for which they have submitted their consent. That is the 22 secured creditors. This bench has considered the submissions made by the learned counsel for the applicant companies with respect to holding the meetings of equity shareholders, secured creditors, and unsecured creditors or getting their consent affidavits. The 6 transferor companies have already complied with the requirements by submitting the consent affidavits of equity shareholders and unsecured creditors. There are no secured creditors in these transferor companies. This bench is of the considered opinion that in view of the advent of IBC 2016, that is the Insolvency and Bankruptcy Code, where a creditor having outstanding of ₹1 crore and above can bring insolvency petition against the corporate debtor, it will be in the fitness of the things that a scheme of merger should have consent of equity shareholders either in duly constituted meeting or by way of consent affidavits filed. Further, the consent affidavits of secured creditors of 1881 crore of transferee company has also been provided by the transferee company as detailed above. The condition of consent affidavit of the secured creditors has been complied. The transferee company has not submitted the list of equity shareholders and unsecured creditors. As far as the meeting consent affidavit of equity shareholders of the transferee company are concerned, the transferee company will submit consent affidavits of the equity shareholders of the transferee company or hold the meeting of the equity shareholders before filing of the company petition. In case the transferee company chooses for the meeting of equity shareholders, the same may be held on 22nd December 2021, Wednesday at 11 AM at the registered office of the transferee company or at any convenient place in Mumbai. The chairman managing director of the transferee company will be the chairperson of the meeting of the equity shareholders. At least 30 clear days before the aforesaid meeting of the equity shareholders of the transferee company be held as aforesaid, a notice convening the said meeting at the day, date, time and aforesaid together with copies of the scheme and explanatory statement required to be sent under section 230 subsection 3 of the Companies Act read with rules so and so shall be sent by registered post, speed post to the equity shareholders whose email addresses are registered with the transferee company, addressed to each of the shareholders at the last known email address as per the records of the transferee company. So advertisements were also directed to be published since there was a meeting to be held. Sending of notices by registered post AD and email to whose email IDs are available, and file consent affidavits of unsecured creditors or at least of the value of 90% at the time of filing of company petition. The bench has also observed that there are 7 IBC proceedings pending against the applicant companies, the list of which has been filed by the applicant companies by additional affidavit dated 11 June 2021. The applicant companies are directed to issue notice of scheme by registered post, speed post and email upon the petitioners who have filed the insolvency proceedings against the applicant companies, and specific consents of these petitioners of the IBC proceedings is to be submitted at the time of filing the company petition. Companies to file affidavit of service, etc. So the order also said that even all the IBC proceedings, we need to file consent affidavits, and of those people who have filed IBC proceedings against us, they may be frivolous, they may be under challenge, but still the bench ordered that unless you file consents from these people who have filed IBC proceedings against your companies, the scheme will not proceed forward. So in this case, the matter went to Honorable NCLT and the Honorable NCLT observed. To reiterate, we observed that the rights and liabilities of secured and unsecured creditors were not getting affected in any manner by way of the proposed scheme, as no new shares are being issued by the transferor company and no compromise is offered to any secured and unsecured creditors of the transferee company. Therefore, we are of the considered view that when the transferor and transferee company involve a parent company and a wholly owned subsidiary, the meeting of equity shareholders, secured creditors and unsecured creditors can be dispensed with, as the facts of this case substantiate that the rights of equity shareholders of the transferee company are not being affected. Therefore, we hold that obtaining 90% consent affidavits from its unsecured creditors is not required, keeping in view the facts of the attendant case. So this is the judgment of the Honorable NCLT in this matter. We will just see the paragraph of passing the order. Yes. It is seen that section 232(1) of the Companies Act 2013 uses the word may, which introduces an element of discretion to the tribunal to be exercised in the interest of justice in appropriate situations. It is evident from the aforesaid citations that the high courts have exercised this discretion, dispensing with the requirement of convening the meetings if the bench is satisfied in all respects. Section 232 is a specific provision carved out by the legislature when both conditions maintained in clauses A and B of subsection 1 of section 232 are met. In the instant case, the amalgamation sought is for between a wholly owned subsidiary and the holding company. The point which needs to be noted is whether such an arrangement alters the rights of stakeholders of the company, whether such an amalgamation has any bearing internally on the creditors or members of both the companies, whether or not the subject meeting would amount to violation of any of the provisions of the Companies Act 2013, whether the tribunal can exercise their discretion when the transferor company is a wholly owned subsidiary of the transferee company and its financial position of the transferee company is positive and the merger is not affecting the rights of shareholders or creditors. The material on record establishes that the transferee company is a wholly owned subsidiary of the transferor company and there is no issuance of any new shares and therefore there is no reorganization of share capital and consequently no arrangement wherein shareholders have to compromise with the creditors of the transferor company. To reiterate, we observe that the rights and liabilities of secured and unsecured creditors were not getting affected in any manner by way of the proposed scheme, as no new shares are being issued by the transferor company and no compromise is offered to any secured and unsecured creditors of the transferee company. Therefore, we are of the considered view that when the transferor and transferee company involve a parent company and a wholly owned subsidiary, the meeting of equity shareholders, secured creditors and unsecured creditors can be dispensed with, as the fact of this case substantiates that the right of the equity shareholders of the transferee company are not being affected. Therefore, we hold that obtaining 90% consent affidavits from its unsecured creditors is not required, keeping in view the facts of the attendant case. For the aforementioned reasons, we allow this appeal and set aside the order of NCLT with respect to directions regarding dispensation of meetings of equity shareholders and creditors only. So this order was passed on 22nd December 2021 by Honorable NCLT, which set aside that portion of the NCLT order which required convening of meetings of shareholders and unsecured creditors or get 90% consent affidavits. So another judgment in case of Axilis Solutions Private Limited dealt with whether appointed date can be changed by the tribunal. So what happened was that NCLT Mumbai modified the appointed date from 7th October 2017 to 1st April 2018 on the ground that considerable time has lapsed from the appointed date as mentioned in the scheme, and the board resolution of the scheme is dated 27th March 2018 and valuation report is dated 22nd March 2018. The Honorable NCLT observed after relying on various judgments that we are of the considered view that the exercising jurisdiction by the NCLT Mumbai to modify the appointed date from 7th October 17 to 1st April 18 in the facts of this case was unwarranted. Thus, the impugned order, so far as the modification of appointed date is concerned, is set aside as, and the appointed date as per the scheme is fixed as 7th October 2017, which is approved by the shareholders of the appellant company. So we will just see this judgment in brief. So this was passed by Honorable NCLT. So it says, once the aforesaid broad parameters about the requirements of a scheme for getting sanction of the court are found to have been met, the court will have no further jurisdiction to sit in appeal over the commercial wisdom of the majority of the class of persons who with their open eyes have given their approval to the scheme, even if in the view of the court there would be a better scheme for the company and its members or creditors for whom the scheme is framed. The court cannot refuse to sanction such a scheme on a ground that it would otherwise amount to the court exercising appellate jurisdiction over the scheme rather than its supervisory jurisdiction. It is the commercial wisdom of the parties to the scheme who have taken an informed decision about the usefulness and propriety of the scheme by supporting it by the requisite majority vote that has to be kept in view by the court. The court has neither the expertise nor the jurisdiction to delve deep into the commercial wisdom exercised by the creditors and members of the company who have ratified the scheme with the requisite majority. The jurisdiction of the company court while sanctioning the scheme is supervisory only, to observe that the procedure set out in the act is met and complied with, and that the proposed scheme of compromise or arrangement is not violative of any provision of law, unconscionable or contrary to public policy. The court is not to exercise the appellate jurisdiction and examine the commercial wisdom of the compromise or arrangement arrived at between the parties. The role of the court is that of an umpire in a game to see that the teams play their role as per the rules and do not overstep the limits. Subject to that, how best the game is to be played is left to the players and not to the umpire. With the aforesaid, we are of the considered view that the exercising jurisdiction by the NCLT Mumbai to modify the appointed date from 7th October 17 to 1st April 18 in the facts of this case was unwarranted. Thus, the impugned order, so far as the modification of appointed date is concerned, is set aside, and the appointed date as per the scheme is fixed as 7th October 17, which is approved by the shareholders of the appellant company. For the compliance of directions in para 22 and 23 of the impugned order, we extend the period now 30 and 60 days respectively, calculate from the receipt of the certified copy of this order. It is also made clear that para 24 of the impugned order, effective date of the scheme shall be the date on which the certified copy of this order along with sanctioning scheme are filed with both ROC Mumbai and New Delhi. Remaining conditions of the impugned order in para 24 will be the same. Thus, the appeal is allowed. However, no order as to cost. So, the Honorable NCLT said that NCLT could not have changed the appointed date once it is approved by the shareholders. Another recent judgment being of Chawla Brothers Private Limited. So, in which NCLT Mumbai dealt with a case where under section 66 can reduction of share capital be done by transferring an asset or a property. Generally under section 66, it is the cash consideration which is paid to the shareholders whose shares are being reduced. But in this case, which was a unique case before NCLT, there were two brothers. So one of the brothers was walking out of the company, and since the company did not have money to pay the brother who was walking out, it directed that a piece of land of the company would be given to him in consideration in exchange of his shares. The shares were cancelled, and a piece of land, as per the valuation, was given away under section 66 of the Companies Act. So we will just see this judgment in brief. This was NCLT Mumbai, 30th of April 2021. So what the company contemplated was that a special resolution was passed on 7th of March 2020, and it was proposed that reduction of its existing equity capital by reducing the paid up equity share capital from 48,01,000 rupees divided into 48,000 equity shares of rupees 100 each, fully paid up, to 21,12,500 divided into 21,125 shares of rupees 100 each, fully paid up by 2.5 of the scheme, bearing CTS number so and so, and cancelling and extinguishing 26,885 fully paid up equity shares of rupees 100 each, held by Prasoon Spaces LLP. So this was the shareholder seeking an exit from the company. The shareholder was an LLP, the shareholder of the petitioner company, and lieu of the cancelled equity shares transferred to Messrs. Prasoon Spaces LLP, the shareholder of the petitioner company, part of the property as defined in para 2.5 of the scheme, bearing CTS number so and so, area of 7,904 square meters, part of the property, and remitting a sum of rupees 388.87 per equity shares, which is cancelled and aforesaid. Similarly, preference shares were also being reduced, and the said LLP was being paid consideration in the form of land. So this was the shareholding pattern of the company. There were a total of 4 shareholders. So one shareholder holding 56% was seeking an exit. The other 3 shareholders would continue with the company. The preference shareholders, again, there were 3 and one was being given an exit. That is shareholder number 1. So the petitioner company was the owner of the property located at CTS number so and so, Chandivali Road of Saki Vihar Road, Andheri, measuring 16,299 square meters, along with industrial structure on the plot. The said plots are lying idle and currently no business is being carried out thereon. There were only 4 shareholders. They have mentioned the articles of association, which is Article 7, which empowers the petitioner company to reduce the share capital, which has been reproduced. The company may from time to time by special resolution and subject to confirmation by the court and subject to provisions of 104 of the Act, reduce its share capital in the manner prescribed therein. So on receiving the request from this shareholder, that is Prasoon Spaces LLP, the petitioner company obtained a valuation report from Messrs. J.M. Mehta and Associates, Chartered Accountants. As per valuation report, the fair value of the equity and preference shareholder held by the shareholder Prasoon Spaces LLP and the fair value of the part of the property and share in net assets to be transferred as consideration in lieu of extinguishment of shares is as under. So this was the valuation. So total fair value of the equity shares was 49 crores 72 lakhs, and with the preference shares it was around 55 crores. So the value of the land as per the valuation was around 54 crores, and 1 crore 4 lakhs was proposed to be paid in cash. So this total amount of 54 crore 97,070 54 crore 97 lakh 73,377 was matched with an asset of 53.93 crores and cash consideration of 1.04 crores. So the figure was completely matched, and thereafter the board passed this resolution to reduce this share capital. Shareholders meetings were held, and thereafter the petition was filed with Mumbai NCLT. So the first order was passed by Mumbai NCLT on 24 July 2020 to direct publication of notices and intimation to regulatory authorities to file the report and fix the matter for final hearing. Newspaper advertisements were also published. In this case, the observation of the regional director was that it is respectfully submitted that the petitioner company is proposing to reduce the paid up share capital by cancelling and extinguishing 26,885 equity shares of rupees 100 each. The company shall, in lieu of the cancelled equity shares, transfer to the shareholder of the company part of the property and remit to the LLP a sum of rupees 388.87 per equity share, and also reduce the paid up share capital by cancelling and extinguishing of 5,25,000 redeemable preference shares of ₹100 each. The company shall, in lieu of the cancelled preference shares, transfer to the shareholder of the company part of the property bearing CTS number so and so, having area of 855.57 square meters. In this regard, it is submitted that the proposed reduction of share capital is selective reduction. The reduction of capital is selective, is detriment and unjust and unfair to the rest of the shareholders, public members holding equity share capital of the company. The reduction of share capital should be across the board and not in selective manner. In this regard, it is further submitted that the present scheme is not falling strictly under Section 66 of the Companies Act, but the scheme appears to be in the nature of sale of assets, that is plot of land in guise of the scheme. The provisions of Section 66 were introduced by the RD. So at the end, it is said that it is seen that the provision of Section 66 do not permit such reduction and transfer of assets. So without prejudice to the above, the applicant to submit an affidavit to the effect that the interest of the creditors and all stakeholders in government revenue are protected as well as statutory dues are paid off. The tax implication, if any, arising out of the proposal for reduction is subject to a final decision of income tax authorities. The approval of the company petition by this honorable court may not deter the income tax authority to scrutinize the tax return filed by the company after giving effect to the proposed reduction. The decision of the income tax authority is binding on the petitioner company. So the findings of NCLT were that the share capital needs to be reduced by way of consideration in terms of property, and they have incorporated the details from the valuation report as far as the valuation and cash consideration is concerned. And they have, yes, the voting pattern as per the meeting of the shareholders show that it was approved by 100% of the shareholders. And they have justified the valuation, stating that it has been made as per the accounting practices and as per the valuation report. There were no secured and unsecured creditors. There was no public interest. So they have clearly said no secured and unsecured creditors as on 6th March of 2020. The petitioner company further confirms that there are no deposits and no arrears in repayment of deposits and interest thereon. So the legal issue for consideration which arose is that whether in a scheme of reduction of capital, it is permissible for the company to extinguish its liability by paying off its shareholders equity or preference or both in terms of transfer of property as proposed by the petitioner company. The proposed transfer of property in lieu of cancellation and extinguishment of paid up share capital of the petitioner company is well within the four corners of reduction as contemplated under Section 66. So it is pertinent to note that Section 66 is incorporated as follows. So Section 66 was incorporated by Honorable NCLT, and thereafter the council placed on reliance on the judgment of Orissa High Court in OCL Limited on 30th March 1998, wherein it was held that Section 100 of Companies Act 1956 dealt with special resolution for reduction of share capital. In exercising its power, the court will have due regard to the interest of creditors who may consent or object to the reduction. So Section 100 of the Act dealt with special resolution for reduction of share capital. In exercising its power, the court will have due regard to the interest of creditors who may consent or object to the reduction. For a company to reduce its share capital in any manner as set out in Section 100, it must have power given to it under the articles to do so, subject to confirmation by the court as required under Section 101 of the Act. A company may, if authorized by its articles, effect a reduction of its share capital in any way which it may think fit by special resolution. So this part has been mentioned in bold by NCLT, including in any particular way in any of the following ways. So in subsection 3, it says it may pay off any paid up share capital which is found to be in excess of the capital requirements of the company. Thereafter, again, it is specified that subsection 4 states that diminishing the number of shares by extinguishing the existing liability on certain shares, writing off or repaying the whole amount paid up and recalling them. The statute has also not prescribed the manner in which the reduction is to be carried out, nor it has prohibited any method of effecting that object as per Lord Herschel in British American Trustee and Finance Corporation 1894, read with approval by Lord Reed in Westbourne Sugar Refineries at page 85, which added that paying of capital can be done otherwise than by payment of money. Important though task is to see that the procedure by which the resolution is carried through is formally correct and that creditors are not prejudiced. It has a further duty of satisfying itself that the scheme is fair and equitable between the different classes of shareholders. then what is the duty of the court in considering the matter of this kind? In the first place, the interest of creditors must be safeguarded, but here that has been done. Secondly, the interest of shareholders may have to be considered, but in the case there has been no opposition by any shareholder at any time, then it is difficult to see how there could be any prejudice to any single shareholder. Thirdly, there is public interest to consider. The Learned Counsel placed reliance on Bata Properties Limited in the matter of Calcutta High Court, which allowed the petition in which immovable property was transferred to the shareholder on capital reduction. The petition also contained the following reduction: that resolved that subject to confirmation by the court, the share capital of the company now consisting of 8 crores 85 lakhs 10,000 divided into 88 lakhs 51,000 equity shares of rupees 10 each fully paid be reduced to 4 crores 85 lakhs 10,000 divided into 48.51 lakh equity shares of rupees 10 fully paid up by the retransfer of immovable property of the company comprised in its premises at 30 Shakespeare Sarani, Calcutta 17 to Bata India Limited or its nominees. Again, in case of Vodafone Idea Limited, the said order was considered and the resolution stated accordingly that the share capital is being reduced and distribution in consideration, therefore, an aggregate of 5,05,504 equity shares of rupees 1 each, directly or indirectly, beneficially by the company's Indus Towers to the shareholders of the company pro rata to their shareholding of the company. So their shareholders whose shares were being reduced were not paid cash, but they were given shares of Indus Towers Limited. So again, in case of Bata Limited, Farm Enterprises Limited, they have specified that the very same thing, immovable property was given, and such reduction shall be effected by cancelling and extinguishing 8,60,903 fully paid up equity shares of rupees 10 each held by the members of the petitioner company other than company's holding company and associate entries, and in lieu thereof the petitioner company shall transfer to each shareholder as on record date other than the holding company and associate entries 1 equity share of rupees face value 10 of Reliance Industries Limited for every equity share of the face value rupees 10 of the petitioner company. And view of the amendments in paragraph 15 and 20 of the company scheme petition under section 101 subsection 2 passed in company summons for direction number 123. So in case of Vodafone Idea as well, this was done. Thereafter, the other judgments also were Shantha Ranganathan and others versus Commissioner of Income Tax. So the company effected a reduction in its share capital on May 8, 1962 after getting the requisite sanction of the High Court. The High Court, by an order dated 20th April, sanctioned the reduction of the company as resolved and effected by the special resolution passed at the extraordinary general meeting to reduce the share capital of the company. Mr. So-and-so held 135 shares of rupees 1,000 each in Kasturi Estates. Since the company effected reduction of its capital by rupees 790 per share, the value of the assessee's holding was reduced by 1,06,000 rupees, and hence 1,06,000 rupees was to be returned to the assessee in consequence to the reduction of capital for the 135 shares held by him. Towards this reduction of capital in return of money as per the order of High Court referred above, the assessee obtained cash of 60,683 rupees and the following assets. The book value of the assets came as it would appear to 45,967, while the market value as per wealth tax assessment is at figures against each item. So the total consideration was paid in cash as well as property. So in this case also, property in addition to payment of money were distributed in lieu of reduction of share capital to the shareholders of the company. The Learned Counsel also, upon the judgment of Honorable Supreme Court in case of Commissioner of Income Tax Madras versus G. Narasimhan, the facts stated above are reiterated as follows.
Ashwin, can I just take your 2 minutes, sir, Ashish bhai?
Yes, yes.
Okay, because we would like to recognize the presence of our past convener and the core group member and the newly elected regional council member,
Yes,
Pinky. So before we congratulate Pinky Madam, I would like to congratulate the entire team because we have now the new vibrant team, the new torchbearer WRC team for the year 22-23. CA Murtuja Kachwala as in chairman, CA Yashwant Kasar as in vice chairman, CA Shweta Jain secretary, CA Piyush Chandak as in okay, yeah, treasurer, and the our Ketan Sayya Bhai as in Vikasa chairman. So we would like to congratulate the entire new torchbearer team for the year 22-23. And with this, we are recognizing the presence of our past convener and core group member and the newly elected regional council member CA Pinky Kedia ji, since he is there on our virtual platform. So we congratulate madam, and we hope you will give your best for this term. And thank you, Pinky madam, for your presence. Right?
Thank you. So,
Okay, Ashish bhai, I think now you can continue. And I'm very sorry we have interrupt you during your session.
No issues. We'll just start.
Please carry on.
thank you.
Thank you.
Yes. So an appropriate order was obtained from the court. Reduction was given on and from 20th May 1962. So as a result of this reduction, there was a pro rata distribution of some properties of the company and payment of money to the shareholders, including the assessees. So there were various judgments in which the court held that reduction of share capital also is not necessary that it should be in terms of money. It can be in terms of other assets as well, including cash. So in case of Reckitt Benekiser, reported in 2005, which passed by Justice A.K. Sikri, also category held that it is a settled law that question of reduction of share capital is treated as a matter of domestic concern and the decision of majority will prevail. Further, the petitioner company has also filed a rejoinder and have dealt with the observations of the regional director. The learned counsel for the petitioner company submits that the petitioner company has filed an affidavit of rejoinder dated 26 November 2020 with this honorable tribunal, and also the regional director to allay the reservations expressed by the regional director in paragraph 7b in the following terms. The petitioner company does not have any secured or unsecured creditors, hence the question of interest of creditors does not arise. The petitioner company has undertaken that interest of all stakeholders of the petitioner company and government revenues are protected, as well as statutory dues are paid off. The petitioner company has undertaken that it shall comply with all the applicable provisions of Income Tax Act 1961, and all tax issues, if any, arising out of the petition will be met and answered in accordance with the law. And further, the decision of the Income Tax Authority will be binding on the petitioner company, subject to right of appeal available to the petitioner company under the applicable laws. Also, the approval of the petition by this tribunal may not deter the Income Tax Authority to scrutinize the tax return filed by the petitioner company after giving effect to the proposed reduction. Therefore, this bench is of the considered view that reduction of share capital is just and equitable in view of the various decisions of the various courts and in terms of Section 66 of the Companies Act. The application for reduction of share capital is allowed subject to the direction of the herein in above. All concerned regulatory authorities to act upon the production of certified copy of this order issued by the Joint Registrar NCLT Mumbai bench, and advertisements were directed to be published, and the said reduction for consideration other than cash was allowed. Another judgment in case of Ericsson India Private Limited and Ericsson India Global Services Private Limited, NCLT Delhi. So the companies filed first motion application and prayed for dispensation of meetings of equity shareholders and unsecured creditors based on various judgments. Companies filed an affidavit that they do not have any material investigation proceedings. NCLT dismissed the first motion application on the ground that the company has not filed proper affidavit in compliance with provision of Section 232A and has not obtained consents from secured creditors. While dismissing the application, NCLT observed that the companies had not provided the details of material investigations proceedings as required under Section 232A, and that the section does not provide any criteria for considering an event as material. So this was the order of NCLT Delhi, which dismissed the first motion application of Ericsson. So the prayer made is to dispense with the convening and holding of the meetings of shareholders and creditors. It is averred by the applicant companies that the transferor company is a wholly owned subsidiary of the transferee company. The applicants have annexed their affidavits in compliance of Section 230 subsection 2, which is at page number 441 to 450. However, on perusal of those affidavits, there is no specific averment with details to any investigation or proceedings pending against the applicant companies. that while order dated 9th August 2021, this bench had directed the applicant companies to file their affidavit in compliance of Section 232A of the Companies Act 2013, that the applicant companies in response to the same have filed their affidavits on 9th August 2021, stating that there is no investigation or any proceeding pending against the applicant companies. So the company number 1, that is the transferor company, had 473 unsecured creditors. No consent was obtained. The transferee company, that is the applicant company number 2, had 177 unsecured creditors and no consent was obtained from those creditors. All the shareholders had given their consent. So as regards the meeting of unsecured creditors of the applicant companies have sought dispensation of the meeting of unsecured creditors on the grounds mentioned in their averment. So the unsecured creditors referred herein above are in the nature of sundry creditors of the applicant company in its day-to-day business, and they would be paid off in the ordinary course of business. The scheme is in no manner prejudicial to the interest of the said unsecured creditors. In terms of the scheme, no liability of any of the unsecured creditors of the applicant company 1 is proposed to be reduced or extinguished. The net worth of the applicant company number 1 as of 31st January is 23,227 million, that is 2,322 crores. And the pre-amalgamation and post-amalgamation net worth of the applicant company 2 as on 31st January is 33,000 million, that is 3,304 crores, and 55.722, that is 55,702. So this was 5,572 crores. So accordingly, the applicant company 1 and 2 will continue to have sufficient and positive net worth as on 31st January, which indicate that there are sufficient assets to meet the respective liabilities of the companies. In view of the same, the amalgamation of net worth of the applicant company 2 will be sufficient and positive, which will enable the applicant company 2 to meet the aggregate liabilities of each of the applicant companies. A certificate issued by the chartered accountant certifying the net worth, as well as certificate issued by the applicant companies that the pre and post amalgamation net worth as described above is attached. The present scheme is an arrangement between the applicant companies as contemplated under 231B of the Act, as there is no compromise or arrangement with any of the unsecured creditors, as no sacrifice is called for. Alternatively, in the event this honorable bench holds that the meeting of the unsecured creditors of the applicant company 1 cannot be dispensed with, this honorable tribunal may be pleased to pass directions for convening meeting of the unsecured creditors of the applicant 1 to consider the scheme. The applicant companies have filed their written submissions and co-placed reliance on the following judgments of honorable NCLT and coordinate benches. So they also relied on other judgments wherein the dispensation was granted. The applicant companies have stated that post amalgamation, the net worth of the transferee company will be more than its pre-amalgamation net worth, and therefore the interest of the creditors of the transferee company will not be adversely affected. To support this contention, the transferee company annexed a copy of net worth certificate issued by Shiv and Associates Chartered Accountants that the pre-amalgamation, post-amalgamation net worth of the companies. So the CA certificate was also annexed. That from perusal of para 4 and 5 of the aforesaid affidavit, we notice that the transferor company has submitted that as per section 232A of the Companies Act 2013, the applicant company 1 is required to disclose the investigations against the applicant company 1 that are considered as a material fact relating to the applicant company. The applicant company 1 submits that there are no such investigations pending against the applicant company, including section 235 to 251 of the Companies Act 1956 or corresponding notified sections of the Companies Act 2013, that is sections 210 to 17, 19, 20, and other sections of the Companies Act 2013. It also goes on to state that the provisions of section 232A of the Act have been complied with and the necessary disclosures as stated therein have been made in the joint application. On perusal of the aforesaid statement, the details of material investigations or proceedings that have been instituted that are pending against the company, we observe that the applicant companies have subjected the disclosure to the following averment. So this was a disclaimer which they had instituted. To determine whether a particular event or information is material in nature, the criteria mentioned herein shall be applied, an event or information where the value involved or the impact exceeds 10% of the total revenue or 10% of the net worth of the transferor company or the transferee company, whichever is less, based on the last audited financial statements of the company, has been considered material. From the plain reading of the contents of section 232A, it is clear that no criteria for considering a particular event or information as material for declaration under this provision, as the one assumed by the applicant companies, has been prescribed under the Companies Act. Hence, we observe that despite getting an opportunity via our order dated 9th August 2021, the applicant companies have failed to file proper affidavits disclosing the complete particulars of all investigations proceedings pending against each of them, including case number, court in which pending, amount of debt involved, next date of hearing, and the present status of the case. Further, while going through the application and the amendments made therein, we observe that the applicant companies have not taken consent of the creditors having at least 90% in value by way of affidavit on the proposed scheme in terms of provisions of section 230 subsection 9, and have still sought dispensation of calling their meeting on the ground that there will be no sacrifice made towards the unsecured creditors, and the scheme is in no manner prejudicial to the interest of the unsecured creditors. So in our considered view, the unsecured creditors of both the companies cannot be kept in dark. If without their consent affidavits, the meeting of the unsecured creditors is dispensed with, they will be deprived of an opportunity of being heard or oppose the scheme. That the legislature under section 230 subsection 9 of the Companies Act 2013 has not made any exception in case of an amalgamation between a holding and subsidiary company from filing the consent affidavits of creditors, nor it has given any explicit power to this tribunal to dispense with the meeting of the creditors in absence of their consent affidavits in any circumstance. So they reproduce section 230 subsection 9 that 90% consent affidavits are needed. In a sequel to the aforesaid discussion, we conclude that the affidavits filed under 232A of the Companies Act 2013 are incomplete and defective. Further, we are not inclined to dispense with the meeting of the unsecured creditors of the applicant companies in light of the facts of the case and in the absence of their consent affidavits in terms of section 230 subsection 9 of the Companies Act 2013. The application is accordingly dismissed. However, liberty is granted to the applicant companies to file a fresh application on the same cause of action in accordance with the law by complying with all the applicable provisions. So NCLT Delhi dismissed the application of Ericsson for amalgamation on the pretext that they did not obtain consent affidavits from the unsecured creditors. Obviously, the company had approached NCLT. So the Honorable NCLT, in a recent judgment, observed that the applicant, the NCLT set aside the order of NCLT and observed that we are of the considered view that the wording of section 232A should be interpreted as all material facts relating to the company, such as pendency of any investigation of any proceeding against the company. The affidavit filed by the appellant companies discloses all the duly audited financial statements along with the investigations and inquiries which are material to the implementation of the scheme. In any event, as per clause 6 of the scheme, upon this implementation, all proceedings in the name of the transferor company shall be continued and enforced against the transferee company, and such proceedings shall not be discontinued or prejudicially affect anyone by reason of the scheme. Accordingly, the requirements of section 232A of the Act read with rule 638 of the rules are met. So this was the order of Honorable NCLT. The material part of this order is that section 232A of the Act read with rule 638 of the rules shows that the scope and intent is to require companies to disclose all investigation proceedings which are material and relating to the company. We are of the considered view that the wording of section 232A should be interpreted as all material facts relating to companies, such as pendency of any investigation or any proceeding against the company. So since the affidavit discloses all the audited financial statements and the material facts, the NCLT has set aside the judgment of Honorable NCLT. So the appeal is allowed and impugned order is set aside. The registry is directed to upload the judgment and forward it. So the NCLT held that the company has sufficiently complied with the provisions of section 230 and rule 6. So in case of observations of official liquidator, there is one judgment in which the official liquidator made certain observations. In the scheme of amalgamation, So these observations in very brief pertain to the, there was some TDS reimbursable to the company of 98 lakhs, which was debited to the profit and loss account, and which was payable to the erstwhile promoter director. The same was disclosed in the audited accounts. So the summary was that the auditor appointed by the official liquidator felt that according to us, the erstwhile directors have derived undue benefit from such a transaction. Then there were various expenses in relation to share transfer, etc. It should have been incurred by the erstwhile directors. Since it was pertaining to their shares, it is debited to the company. And as such, it is clearly indicated that it is not a business expense, and the erstwhile directors of the company derived undue benefits from such transactions, which is incurred by the company. So in the supplementary report also, it was stated that the directors of VG MedSafe Private Limited has paid the following professional fees for the valuation of the shares of the company, identifying intending buyer for transfer of existing equity shares of the company, and other legal compliance for transfer of shares of the company. The details of expenses are as under. So this was some professional fees paid to various firms for valuing the asset, valuing the company. So the certain comments by the auditor appointed by the OL pertaining to accounting vagaries was before NCLT for consideration whether the affairs of the transferor company have been conducted in a proper manner. So the companies replied to this and said that the transferor company was also a party to the share purchase agreement, and therefore it has taken up the obligation to pay proportionate TDS up to 23rd January 19 to the erstwhile directors. This decision was commercial in nature and in the best interest of the transaction. The transferor company was a 100% promoter-owned company, and hence such TDS refund would have ultimately incurred to the benefit of the erstwhile director promoters only, as there was no outside shareholder. So they have explained all of these contentions. The issue has not been qualified by the statutory auditors of the transferor company in their audit report. So there was no intent to deceive or gain an undue advantage, etc. So they relied on certain judgments that such accounting practices cannot affect the amalgamation. So the petitioner companies explained the relevant observations of the official liquidator, and thereafter the NCLT in its order said that there are two issues to be considered, that of the TDS reimbursable pertaining to the tune of 98 lakh rupees is debited to P&L, and professional and consultancy fees which has been paid. So as far as the first issue is concerned, this bench feels that it is only a question of accounting for the same under the wrong head of account. Mere mistakes in accounting practice would not be enough to scuttle the sanction of the scheme. And they have also referred to some judgments of the Gujarat High Court, which held that mere mistakes or error in adopting accounting practices cannot amount to misfeasance unless it resulted in any loss to the company or undue gain to the directors or other persons. There is no allegation that there was fraudulent conduct of the business. Further, the statutory auditors have not qualified the report for the relevant time. Learned counsel for the petitioner company submits that in any case, the petitioner companies have stated that the said expense has been disallowed by the transferor company by filing its income tax return for 18-19. Now, regarding payment of professional fees, Learned counsel submits that it would be left to the commercial wisdom of the board of directors, and the shareholders of the company have also considered and unanimously approved the audited financial statements at their AGM. There was no undue tax benefit or advantage of any kind. So therefore, after hearing the averments, and it is a matter of commercial expediency to incur such expenses, and these will ipso facto would not be enough to reject the scheme unless it can be shown that such expenditure is fraudulent in nature or for similar reasons. So official liquidator has also not said that there is fraudulent conduct of business, and the business has been carried out in a manner which is prejudicial to public interest. So the arguments of the counsel for the petitioner companies was accepted, and the scheme was accordingly sanctioned. So in short, a fast track merger. Following companies are eligible for fast track merger, holding in wholly owned subsidiary between the small companies, having paid up share capital of which does not exceed 50 lakh rupees, and turnover of which as per its last profit and loss account for the immediately preceding financial year does not exceed 2 crore rupees. The procedure in short is drafting of the scheme of merger, convening the board meeting for the approval of scheme, filing of notice along with a copy of scheme of merger for inviting objections or suggestions if any in form CAA 9 to registrar of companies in e-form GNL 1, official liquidator or persons affected by the scheme, filing of declaration of solvency with ROC in form CAA 10 in e-form GNL2 along with copy of board resolution, statement of assets and liabilities, auditor's report on the statement of assets and liabilities, issuing notice of the meeting of shareholders along with the scheme, issue notice along with the scheme to the creditors of the company, convening general meeting of shareholders. So meeting of shareholders is mandatory in case of fast track merger, and obtaining approval of shareholders holding at least 90% of the total number of shares irrespective of those present in the meeting. So in case a wholly owned subsidiary is merged with a listed company, it is not possible to go under the fast track route because you will not be able to get consents of 90% of the shareholders of the listed company. So convening general meeting of creditors and obtaining the approval of creditors, majority representing 9/10 in value if the creditors irrespective of those present in the meeting. Transferee company has to file the approved scheme and report of the results of the meetings in form CAA 11 along with the notice earlier sent to RD, ROC, official liquidator. Registrar of companies and official liquidator may give objections or suggestions, if any, to the regional director within 30 days of the receipt of the scheme. In case of no objections, the RD shall register the same and issue the confirmation thereof to the company in form CAA 12. In case of any objections or suggestions from ROC and OL, or if RD is of the opinion that the scheme is not in public interest, it may file an application before the tribunal in form CAA 13 for consideration within a period of 60 days from the receipt of the scheme. Thereafter, the final order passed by the regional director approving the scheme in form INC 28 with ROC within 30 days needs to be filed. However, friends, the experience has been practically that the fast track merger sometimes takes more time than the NCLT merger. So ultimately, to deal with the government departments to ensure that the reports are sent, there may be a formal hearing. So it has been a tough time handling fast track mergers. So it is always advised that NCLT route is always better, even in case we qualify for the criteria for a fast track merger. So there are some frequently asked questions: how to prepare for the hearing. We need to actually see the other matters which are being heard and understand the requirements of the bench as well as the present practice. Only then we will be in a position to prepare for our hearing. So we need to keep all necessary papers ready or line of argument ready in order to prepare for the hearing. In the application, we have prayed for convening of meetings of creditors and shareholders. However, we now want to seek dispensation. Is it possible? Yes, it is possible. We can file an additional affidavit and modify our prayer. And in the additional affidavit, we can attach the consents of all the shareholders. And accordingly, NCLT will take the additional affidavit on record and allow dispensation of the meetings of shareholders as well as creditors. An order for convening meetings of creditors and shareholders has already been passed. Is there still a possibility of seeking dispensation? Yes, you can file a company application. You can attach the consents of all the equity shareholders and pray that directions be issued to serve notices to creditors and the earlier direction of calling meetings be amended. So NCLT would take on record the said company application and allow dispensation of meetings of shareholders and issue directions to serve notices upon creditors. I have filed a merger application long time ago, but the same is not being listed for hearing. What should I do? If there is a possibility that may be stuck in either a technical issue or there may be some problems with the scrutiny. So an effort needs to be made to visit the registry and find out exactly what is the issue. Else the said merger application will lie as long as it can. So some intervention would be required to understand what the nature of the problem is. Is it mandatory to send notice to all the creditors? In case of large companies, it is seen that there are very small creditors also. So the bench is allowed to fix a threshold. Say, for example, if you issue notices to creditors having a value of 10 lakh rupees and above, so you can, and if they constitute more than 95% of the total creditors, you can set a threshold. So the other creditors having a value of rupees below rupees 10 lakh, you will not be required to send notices. So an effort can be made to explain to the bench that since it is a large company, we should be allowed to send notices to creditors holding a debt of a particular value, so that all those people who are holding below that, they need not be served notices. The auditor appointed by the OL is asking for the documents from the transferee company, whether he is entitled to the same. He is entitled for the same as a point of reference. However, the audit needs to be done only for the transferor companies. Can objections from income tax department stop the merger? Whether NOC from income tax department is mandatory. So objections from income tax department are to be heard by the NCLT, and in case it deals with evading government revenue, then yes, definitely it can stop the amalgamation. And NOC from income tax department is not mandatory here in Mumbai, since the act provides that within 30 days of the application, if the income tax department doesn't file any representation, then it will be deemed that it has no objection. But the practice varies from tribunal to tribunal. So at least in Mumbai, the NOC from income tax department is not necessary for a scheme of amalgamation or arrangement. Can I change the appointed date after filing the petition or application? Yes, you can move a company application and the appointed date can be changed. How do I apply for certified true copies of the final order? Any cost to be paid for the same. Certified true copies have to be applied by way of an application to the registrar, wherein the same can be issued only after the order is uploaded. The copy of the scheme needs to be printed from our end and handed over to the registry along with the application. One copy for every company is free. Beyond that, the cost at the rate of ₹5 per page has to be paid. So if your order is of 20 pages and the scheme is of 30 pages, 50 pages, so 250 rupees will be the cost to get any additional certified true copy. So the cost has to be paid through Bharat Kosh and the receipt has to be attached, and only thereafter the additional certified true copies will be issued by the registry. What precautions should be taken while filing Form INC 28? In Form INC 28, the most important precaution is to select the right option in the drop-down menu. So there is an option of section 230, 232 merger that has to be selected. At many times it is seen that the option selected is others. So if others is selected, upon approval of the form, the status of the transferor company will not change to amalgamated, it will remain active. And there have been cases where those companies have been struck off after 3 years and the directors have been disqualified, and people have approached NCLT to revive those companies just for the sake of getting those amalgamated with the transferee company. So filing of INC 28, it requires a lot of caution. And approval of INC 28, post approval, we need to check the status of the transferor company, that the status has changed to amalgamated. Only then we are sure that INC 28 has been filed and taken on record properly. What can be issues in approval of Form INC 28? The major issue is that open SRNs. So if any SRN is pending, like if a charge form was filed belatedly and we have not applied for compounding and condonation of delay, that charge form remains open. There may be some other SRNs which may remain open, like some old form which has been filed and not approved by ROC. So these are the general problems while approval of INC 28. The forms of the transferor companies will get approved, but the transferee companies form will be stuck because there are some open SRNs in the transferor companies. I could not file INC 28 on time. What do I do? See, we have two options. One, you can move an application to NCLT to enlarge the time for filing the said form, or you will have to otherwise file an application to the central government, New Delhi, seeking for condonation of delay. So the easier process is to allow to move NCLT with a company application. So they generally are considerate and allow further time to file the said form. After filing Form INC 28, do I need to file any form for the transferor company? It is not needed, since the status will change to amalgamated very, very soon. That is all, friends, from my end today. So in case of any questions, we'll be happy to take up the same.
Yeah, Rahul Dagaji.
Yeah.
Is there
So,
any-
there are some questions. I'll share my screen and then
Yes, sir.
Is the screen visible?
Yes, yes, sir.
Do you want me to read out or?
I will read it. I will read it. No
Okay.
problem.
Okay.
Whether family arrangement can be an object for demerger in the scheme of demerger, and if the existing company has only one line of business, will it fulfill?
This screen is not stable.
Yes, screen is not stable, sir.
Just a minute. Is it fine now?
It is still
Otherwise, Rahul,
Yeah.
so if it is not stable at your end, so can you just mail me so that
Yeah, I'm just mailing it to you. Yes.
I think it is better now, sir. Oh, it's
Okay.
gone.
Okay, it was better.
just check? No, I think network issue is there. That now,
I'll just mail you, sir.
yeah. Or otherwise, can you read at your end? So it will.
Yeah, yeah. Yeah.
I think that will better.
So,
Yes.
whether family arrangement can be an object for demerger in the scheme of demerger, and if the existing company has only one line of business, will it fulfill the definition of undertaking under the Income Tax Act? If the demerged entity will also be in the same line of business as the original company even after demerger.
Yes, a family arrangement is very commonly seen in case of demergers. In such cases, what can be done to fulfill the compliance of Income Tax Act? Say, for example, if it is a textile manufacturing company, it can be divided into two different undertakings. One is, say, for example, a particular fabric division, and the other can be a separate fabric division. So that can be an internal arrangement between the company, just to ensure that one division is going into another company. So there can be an internal alignment of the undertakings, and the said demerger will be in compliance of the Income Tax Act.
Okay. Second question, whether there is a panel maintained by the NCLT for auditors and valuers.
Presently, there is only a panel for for appointment of auditor to scrutinize the books of accounts. Panel of valuers is still not there at the official liquidator's office.
Okay. Third question, does the NCLT site allows one to check the stage where the company's application lies? Also, if one is not aware which bench the application has been filed, how to check?
Yes, on the NCLT website, there is an option to check the case status. In the case status, there are various options. You can search with the name of the company. You can type the name of the company and also find out. Else, you can do one more thing on Google. You can type NCLT e-filing public. So a separate window opens in which it is very easy to locate the details of the cases and the next dates and before which court it is. It is not actually very much popular, but this is the one which we use to track our cases as well as other cases on the orders to be uploaded, etc., etc. So NCLT e-filing public is a very good option for that.
Okay. Next one. GSCL is another interesting case where the company prior to the final order for demerger sold part business textile unit to Indocount. It is now filed a fresh scheme of demerger of chemical and remaining spinning units. I think so. That is just an additional information.
Yes, so there are various types of arrangements which can take place since it is a very wide term. So it is quite common.
Okay. Any other? There are no other questions with me, sir. Krishna Kumar.
Yeah. Jayasji, are you there?
Yes, bole sir.
Yes. So Ashishji, it was a wonderful and great session, and more than 150 participants were there regularly, and still there are more than 140, and the participants have benefited by your session. It was excellent, and you have taken the time to this Saturday afternoon for us. So now I request our Deputy Convener Jayesh Thakkarji to give a formal vote of thanks to Ashishji. Over to you, Jayeshji.
Yeah, thank you, Krishna ji, for this opportunity. And today's speaker, CS Ashish Lalpuria ji, has put in his best efforts to explain us, to enlighten us with wisdom of the words of wisdom on the topic of amalgamation, merger, demerger, and the fast track merger. Also, he is covered. So today is the scenario where the startups and the consolidations of the business, the way it is going on, this was the right time we thought, and we also got the proper speaker, CS Ashish Lalpuria ji. and he's enlightened us with these his view. Even though the topic was very much theoretical, but he has explained us in a way. He has covered all the citations and the latest case studies. So that's how he's made these sessions very live and interactive. So thank you, Ashish Bhai, for giving your valuable time to us on this Saturday evening and to on a busy schedule. So thank you, Ashish Bhai, and thank you all the participants. Thank you, Rahul Bhai, for coordinating today's session. And thank you, Krishna ji, for this opportunity again. Over to you, Krishna ji.
Thank you, sir. Then we are closing the session and we will call you again at an appropriate time.
Sure,
Yeah.
sure. We'll mail the presentation and the judgments to the email address of the chapter of the study session.
Yes,
Sure.
yes. Now, with the permission of the members, we are closing the session. Thank you.
Thank you. Thank you.
Thank you at all.
Thank you.